Good day, madam. We are from lecture 1, tutorial 13. Today we'll be presenting on the AIDA case. I'm Hafsan Akiba. We'll talk about situation 1. The Cepat Sihat SDM a Malaysian pharmaceutical company, launched a nationwide advertisement for its latest product, the Immunipatch, claiming it could prevent serious skin allergies and infections caused by environmental pollution. The advertisement stated that 10,000 ringgit will be paid to anyone who uses the Immunipatch daily for 30 days, as directed, and still develop a severe skin allergy. To prove our sincerity, 100,000 ringgit has been deposited with June Bank. Encouraged by the advertisement, Ida, a nurse with sensitive skin, bought the Immunipatch and followed all the instructions. Despite this, she developed a serious allergy rash after 3 weeks. When she demanded the 10,000 ringgit reward, the company refused, claiming that the advertisement was merely a promotional gimmick and has no intention to pay anyone. So, the issue is whether Ida is eligible to claim the 10,000 ringgit reward. In Rules and Application, Section 2 Sub A of the Contract Act stated that when one person signifies to another his willingness to do or to abstain from doing anything, with a view to obtaining the assent of the other to make the act or abstinence, he is said to make a proposal. In the case of Carlyle against Carbolic Mobile & Co., the defendant manufactured a flu medicine and advertised in the newspaper and promised to pay £100 whoever used it according to instruction, but still contracted influenza. To show sincerity, the defendant deposited £1,000 into the bank. The court held that the advertisement is a binding offer as it is a unilateral offer, and they had the intention to create legal relations by depositing £1,000 into the bank. Applying this case into the present scenario, Sihat Cepat SDM advertisement had stated that 10,000 ringgit will be paid to anyone who used the product as directed, still develop a severe skin allergy, and to prove sincerity, 100,000 ringgit has been deposited with June Bank. This is similar with the case of Carlyle, as the defendant also promised to pay whoever used it and still contracted influenza, and deposit money to show sincerity. Therefore, Sihat Cepat SDM advertisement is a binding offer. Then, in Section A of the Contract Act stated that the performance of the condition is a proposal, or the acceptance of any consideration offered with a proposal for a reciprocal promise is an acceptance to the proposal. Applying this in the present scenario, Ida bought the Immunipatch and followed all the instructions. Therefore, there is a valid acceptance. In conclusion, a defense that the advertisement is merely a gimmick holds no weight in the eyes of the law, because Cepat Sihat SDM make a specific offer with a clear show of sincerity, and because Ida performed her part of the agreement, a binding contract exists. Therefore, our group position is favored toward Ida, who is legally entitled to claim 10,000 ringgit reward. That's all from me, then I will pass to my friend.
Greetings, madam. My name is Wong Wen Jun and I will be presenting the second issue. First, allow me to go back to the facts of the question. Aida's father, Rahman, had entered into an agreement with his close friend, Johan. Both men agreed that if their children married each other, each father will give 50,000 ringgit to the couple as a wedding gift. When the marriage took place, Rahman fulfilled his promise, but Johan died before making payment. Hafiz and Ida tried to claim the 50,000 ringgit from Johan's estate, but Johan's executor refused, arguing that they were not parties to the contract. The issue of this case is whether Hafiz and Ida are not the parties of the contract able to claim the 50,000 ringgit from Johan's estate. The rules that are applicable is the doctrine of privity. The general rule of privity is that only those parties to the contract may sue or be sued. This can be seen in the case of Twitter and Atkinson. The plaintiff's father and his father-in-law negotiated with each other to pay the plaintiff a certain amount in respect of his planned marriage. After the marriage, the agreement was verified in writing. The plaintiff sued the unpaid number of his father-in-law executioners. The court held that the action was not taken, so no stranger could take advantage of the contract, even though it had been made for its benefit. In addition, he does not provide any consideration. Besides that, in another case named Kepong Prospecting Limited and Schmidt, an agreement was made between Tan and Schmidt, whereby Schmidt was to receive a commission. Tan later transferred the business to a company which agreed to take over the obligation but subsequently refused to pay. The court held that Malaysian law follows the English common law doctrine of privity and does not recognize jus quaesitum tertio. As Schmidt was not a party to the later agreement, he could not enforce it. Applying Twitter and Atkinson in the present case, the agreement was made between Rama and Johan. Although the agreement benefits Aida and Hafiz, but they are not the parties in the agreement. This is similar to the case of Twitter and Atkinson, as the plaintiff's father and his father-in-law had negotiated to pay an amount for their planned marriage, which the parties of the contract are plaintiff's father and his father-in-law. The plaintiff are just benefits from the contract as it is similar in the present case. Therefore, Hafiz and Aida shall not enforce the contract between their father-in-laws by the principle established in this case. By applying Kepong Prospecting Limited and Schmidt, Malaysian law does not allow third parties to enforce a contract merely because it was made for their benefits. Therefore, Aida and Hafiz lack the legal standing to sue Johan's estate for the 50,000 ringgit. In conclusion, the contract between Rama and Johan is only valid and enforceable between the two of them. Hafiz and Aida are strangers to the contract, therefore, they are unable to claim the 50,000 ringgit from Johan estate. Thank you.
To you, Madam Nora. My name is Samuel Chang Zikang, the leader of the group. For my part, I'll be presenting Situation 3, which is the third issue. So, for the third issue, it is whether there was an intention to create legal relationship between Aida and her mother. For the rules of this issue, they are the case of Balfour and Balfour and the case of Jones and Padavaton. In the case of Balfour and Balfour, the court established that a rebuttable presumption that domestic agreements between family members are not intended to be legally binding. The court emphasized that they rely on mutual trust and natural affection rather than legal enforcement. Similarly, in the case of Jones and Padavaton, in that case, a mother had promised an allowance to her daughter in exchange that her daughter need to go for a studying bar. The court held that this was a domestic arrangement in which cannot be a binding contract. Applying these facts and principles into the current case, the situation here is highly similar to the case of Jones and Padavaton, in where both case and this situation, the mother of Aida, similar to the case, have provided money as consideration for their daughter to go to study for law. Other than that, according to the principle of Balfour and Balfour, the court has established that agreements made by family members are not to carry any legal enforcement, but its enforcement are based on mutual trust and natural affection. Therefore, there shall not be any legally binding contract between Aida and her mother. In conclusion, there was no valid contract formed between Aida and her mother. Now I'll pass the floor to my groupmate.
Madam, I'm George and I will be presenting the fourth issue. First, allow me to go back to the fact of the question. Finally, after completing her study, Ida joined the Ministry of Health (MOH) under a 5-year government scholarship bond. 2 years later, she resigned to work overseas. The government demanded that she repay the entire bond amount, but Ida argued that the terms were unfair and constitute a penalty. The issue for this situation is whether the scholarship bond agreement between Ida and Ministry of Health is valid. This issue can be further derived into 2 issues. The first issue is whether Minister of Health able to demand the entire bond for Ida. Section 69 of Contract Act (CA) allows for reimbursement for necessary supply to a person incapable of contracting. According to the case of Government of Malaysia and Guncharan Sikh and others, the court held that necessary must be defined according to the minor's station in life. Crucially, the High Court ruled that education and vocational training are necessary for a minor in Malaysia. The scholarship provided by the Minister of Health enabled Ida to gain a professional qualification and employment, which qualified as a necessary suit to her station in life. Since the scholarship is necessary, the contract falls under the exception to a general rule of wideability, which states in Section 69 of the CA. Following this case, a minor cannot use their age as a defense to avoid liability for education they have already benefited from. Ida is liable to reimburse the government because she received the benefit of the necessary, which is education. The second issue is whether the terms were unfair. In the case of University of Malaya and Lee Ming Chong, the defendant received a scholarship term that required him to serve University of Malaya for at least 5 years after graduate. If breached, he is liable to pay a fixed sum of 5,000 ringgit on demand. However, he resigned after 2.5 years of serving. The Supreme Court allowed the appeal and ruled favor to the university. The contract is valid and Lee is required to pay the 5,000 ringgit on demand, which state on the contract. Applying this case into the present situation, Ida joined MOH under a 5-year scholarship bond. However, 2 years later, he resigned. This is similar to the case of Lee Ming Chong, as he received the scholarship and required to serve UN for at least 5 years, but he resigned after the serving 2.5 years. Therefore, the contract is valid and Ida is required to pay the penalty as she failed to fulfill the term in the agreement. In conclusion, the Ministry of Health are able to demand the entire bond for Ida because the term of the agreement is fair. That's all for my part. Thank you.
Good days to you, madam. I'm Ethan Wong, and today I will be presenting the last situation regarding between Ida and Laila. Let me have a brief recap on the facts of the case. At the same time, Ida planned to buy a house in Seremban from Laila, a property agent. Laila offered to sell the house for 500k, and Ida replied offering 450k instead. Laila rejected the counter offer. A few days later, Ida changed her mind and wrote back, "I agreed to buy at 500k. Laila refused to sell, saying the offer was no longer valid. The central issue we need to determine here is whether there is a binding contract was formed between Ida and Laila regarding the sales of the house. To answer this question, we need to look at the rules of offer and acceptance under the Contract Act 1950. First, let's establish the starting point. Under Section 2, Subsection A of the Contract Act, a proposal exists when one person signified their willingness to do something to obtain action. To apply this in this case, when Laila offered the house for 500k, she made a valid proposal. However, the issue also arises when Ida responds. According to Section 7, Subsection A of the Contract Act states that acceptance must be absolute and unqualified. This means you must accept the exact term offered. Instead of accepting, Ida offered 450k in law, this is not an acceptance, it is a counter offer. To understand this effect, we need to take a look at the landmark case of Hyde against and Ranch. In this case, the defendant offered to sell a farm for £1,000. The plaintiff obtained offer for £950, which was later refused. The plaintiff then tried to accept the original offer of £1,000. The court held that there is no contract exists because the counter offer of £950 had to reject and destroy the original offer. You cannot rewind a dead offer. Applying this case in our current situation, when Ida offered 450,000 ringgit, she legally reject Laila offer original 500,000 offer. That original offer was terminated at that exact moment. So when Ida later wrote, I agreed to buy at 500,000, she wasn't accepting an exacting offer. The original offer was already gone. So we can further support this with the case of Malayan Flour Mills, Berhad against Saw and Saw Ng Chiu and another. In this case, the court emphasized that for a contract to exist, there must be a meeting of the minds with a firm offer and acceptance. Since Ida counter offer act as a rejection, there was no longer valid offer on the table to be accepted. Therefore, Ida's final message was actually a fresh offer, a new proposal, entirely which Ida was fully entitled to refuse. So, in conclusion, there will be no binding contract between Ida and Laila. This is because Ida counter offer destroyed the original proposal under section 7 subsection A of the contract and according to the principle in the case of Hyde against Range. Because the original offer was no longer exist, Ida could not accept it later. Laila is under no legal obligation to sell the house. That is all from me. Thank you.